Thanks very much. I'm going to talk today about a study that I'm doing with Jevin West, who's at the University of Washington. Jevin's doing all the important intellectual stuff. I'm just putting words to it that don't make any sense to him because they have to do with law. But Jevin's an information scientist. He's sort of a leader in network construction and network analysis. And a couple of years ago, we decided to look at some patent issues using some fairly powerful network analytic tools that he and Carl Bergstrom have developed. So this will all be, hey Sean, how are you? This will all be greasy kid stuff to you, but patents are not isolated items. They are connected to one another, often quite frequently, both in the future and in the past through backward and forward citations. Millions of patents today, millions of US patents, are connected by tens of millions of citations, and I'll give you some more specific information about that, about our network in a second. Patents and citations form this gigantic network, and the patents are the nodes of the network. They're the dots in the middle, and the citations the links between them. And on the right-hand side of the slide here, you can see a network citation analysis of the scientific literature. And you can see that entire fields are linked to other fields through individual studies. And this is a 30,000-foot overview. But if you drilled down, you'd see many more fine detail connections between individual scientific references. Well, patents are similar in a lot of ways to scientific references and how they connect in networks. So the network represents all of the millions of choices that individual patent applicants have made about where to situate their inventions, where they think their inventions fit in the broader realm of inventing and of science and of knowledge generation. The structure of the network has a tremendous amount of information pregnant in it, and we're trying to mine some of that information by constructing these networks. And hopefully we'll show you some interesting stuff that we've come up with so far. So we use eigenvector centrality and a hierarchical graphical approach. Again, the heavy lifting, the smart stuff, the stuff that involves real intelligence, that's Jevin and Carl Bergstrom, who came up with some of the initial algorithms for this particular approach. So here's some raw statistics. In our network, the graph that we're basing these results on, we have about 4.5 million patents, utility patents, about 500,000 design patents, almost 20,000 plants, about 16,000 reissues, or 15 to 16,000 reissues. Statutory invention registrations, an almost mythical beast that almost nobody knows about, even within patents. There's actually 2,200 of them. And then defensive publications, there's about 500. These are some of the sources for the methods, and I won't go into the methods too deeply, but these are great papers. Rosvall is a scientist in Sweden who's worked a lot with Bergstrom and West coming up with these analytical techniques. So here are two of the sort of foundational papers for the methods that we use. We use this hierarchical map equation, which is this, and hopefully you understand it in detail better than I do. But the map equation basically calculates the description length for a particular hierarchical structure. There's a big trade-off in building these networks between the detail that you can generate and the calculability of the network. And there's a basic mathematical problem called the NP-complete problem. And believe it or not, when I was doing my PhD, I actually dealt with the NP-complete problem in a different sense. I was building phylogenetic trees based on genes of different organisms. And the NP-complete problem is the traveling salesman problem that you might have heard of. You've got a traveling salesman, or a woman, and she wants to travel to as many potential sales as possible in the least amount of time. Now, if there's only 4 or 5 houses to visit, she can calculate an exact answer pretty quickly. Once it gets up to 12 houses, it begins to be quite difficult for her to come up with a really, really good answer. You start having to use heuristic algorithms to calculate it. When you have 6.5 million patents, then it becomes incredibly difficult, and you really just have to approximate. So calculating the graph, or calculating the pattern of the network, becomes really an intractable problem. And you can either focus in on parts of the network and get really good detail, or you can calculate approximations for the whole thing. I know I'm glossing over this, and there's probably several people in the audience who know this 10 times better than I do, but there is this trade-off. The map equation that Bergstrom Rossvall came up with it's been tested in several peer-reviewed studies, and it actually has some very clever ways of bridging between the detail and the calculability problems. And it turns out to be the most efficient and most detailed way of building these networks. So one way to think about the approach that we take is to look at this. This is the scientific literature. This is actually the literature on network science. And Barabasi is one of the foundational groups, or one of the foundational scientists on network studies. This is an oversimplification of the field. These are the connections between Barabasi papers, Bogoletti papers, etc. But if you take Barabasi and you blow that node up, there's actually a lot more detail inside it. So it turns out that this node is actually much more detailed, and there's all sorts of other connections within it, and you can blow up that node again, and you can keep going and keep going. The patent network, you can do this 9 times, which is actually pretty impressive. It's one of the deepest networks that's been studied, which is sort of either a really great thing, we can pat ourselves in the back as patent folks, or a terrible thing for calculability. Here is what you can get when you produce a grand graph of all of scientific knowledge, for example. So this is not patents, this is back to the scientific literature, which has been fairly well studied. And you can see that there are connections between fields like molecular and cellular biology and ophthalmology. And then there are sometimes isolated fields like economics, statistics, political science that don't seem to connect to a lot of the other, well, to physical sciences, ecology, and to biological sciences. And sometimes there are really funky connections. Like neuroscience didn't even exist as an identified field 25 years ago, but it sort of coalesced from a bunch of different sources and became neuroscience. So you can see all sorts of sources coming together in neuroscience. This is just a static view, but you can also do a dynamic view and see these fields evolve. So here's a map of the entire patent system. Pretty easy to interpret, I think. So this is the problem. The problem is that we've got a gigantic network in the data space. So we have about 120 million citations. Almost every single patent since 1975. We've got about 4.2 million European and Japanese patents that are in our network. Patent citations, about 95 million. Non-patent citations, scientific literature, websites, etc., laboratory protocols, about 25 million. And then examiner citations of the 120, only 20 million. So 100 million from applicants, 20 million from examiners. And in another study, we're looking at the difference between examiners and applicants. And there's some interesting differences. So we've got about 20 million nodes. There's a large number of citations per patent, in part because of the ethical and legal obligation to cite. You need to cite material and relevant prior art, and this creates, in some ways, an ideal situation because it forces citations. And to build a network, the more connections, the easier it is to build a rich network. Now, on the other hand, you could criticize this by saying, well, some of these connections might be artificial, because in order to avoid ethical or legal problems, patent attorneys may oversight, and patent examiners might oversight. But in any case, it does produce a rich network. There's a high amount of in-degree and out-degree. The average in-degree for those that care about this sort of network metric is 10.3 for patents. It's very, very high for citation networks in general, higher than the scientific literature. And this may be because of the obligation. There's only 28,000 and change patents that neither cite nor are cited by other patents. I think of them as a very lonely group of patents just hanging out on the edge. Nobody ever asks them to dance. But in the context of the 6.5 million patents, that's not very many wallflowers. The depth of the tree, the number of times you can explode the node, is about 9, which is very, very high for a network. The average times in different parts of the network that you can explode the node and get down to maximum detail is just about 3.9. There's about 500 million unique assignees in our database, so about 10 patents per company. Obviously, this is not evenly distributed. Some companies have 35,000 patents. Lots of companies are singletons. We've found no correlation between the number of claims and citations. We've, again, got another study dealing with correlations between these sorts of things, but that was one interesting thing that we didn't find. So, litigated patents. We decided to look at litigated patents using our network. Are litigated patents simply a random sample of patents, or are they disproportionately important? And I'll explain what I mean by importance in a second, so just hold that thought for a second. This is obviously a well-studied question, and the Allison, Lemley, Moore papers have been really influential in this field. Litigated patents appear to have distinctive characteristics that are markedly true, even more true for patents that are litigated multiple times. Our methods are consistent, our findings, I shouldn't say methods, are consistent with the findings of these studies, but we add a few new tidbits that I think might be interesting. So we had two hypotheses starting out. One is litigated patents tend to be more important than non-litigated patents. And the second, the higher the court level, the more important the patents that are litigated tend to be. Importance is a network measurement. Importance has to do with how many connections you have in the network, and not just the raw number of connections, which is what most citation studies have looked at, but also the quality of the citations. So you could actually have a smaller raw number of citations to your patent, but they might be from very, very influential patents, in which case you may be highly influential, highly important in the network. So this is a quality of the network. This is not a global quality. I'm not saying this patent is important, this is unimportant. Within the context of the graph that we've produced, these are the important patents in the graph. So we've looked at litigations between 2000 and 2014, inclusive of both those dates. Federal district courts, Court of Appeals for the Federal Circuit, and the United States Supreme Court. We've identified patents litigated to a decision. We've yet to actually parse the decisions to figure out what's going on. These are simply patents that appear in decisions. We'll move to the next phase, but as you can imagine, the data gathering is pretty challenging. The completeness of the data set, we have about 40% of all district court cases, which has been a Herculean task for my poor team of research assistants. But they're chugging now. We should have a full set, I think, by mid-October. We have all the CAFC decisions, and we have all the Supreme Court decisions, which is a lot easier. So here's the very first global overview. In our system, we set the mean importance of a patent in the network at 1.0. So here's all patents. The average for all patents is 1.0. That's the average. That's sort of the benchmark. District court, patents litigated in district court, these are about 4.5. So 4.5 times, and this scales directly, so they're 4.5 times more important in the network than the average patent. CAFC, about 6.5, almost 7, and Supreme Court, more than 8. So it's an interesting sort of step-like function here, and it appears to show that the higher you go in appeals, not the number of litigations, but the higher you go in appeals, the more important that population or that sample of patents tends to be. Okay, so here are by districts, and I apologize these are so small, but I wanted you to see the whole majesty of district court data. So this does not include every district. This is the first, second, third, let's see, we've got the 4th, we've got the 5th, the 9th, and the 10th. We also have the Federal Circuit, as I said. So when I say we've got these circuits, these are all the districts within those circuits. So you can see there's quite a bit of variance. District of Connecticut is very, very high. It also has a relatively modest sample size. So sample is population size, pardon me, because this is every single case, and a gigantic standard deviation. These are all standard deviation measurements. On the other hand, District of Arizona, Eastern District of California, Hawaii, Idaho, Western District of Washington, and District of Wyoming, very, very low. So lots of interesting stuff going on in the districts. We'll flesh these out to include every district, like I said, by mid-October. Here I've aggregated the district courts into their circuits, knowing full well that the circuit courts generally don't hear patent cases. But here are all the district courts within the First Circuit, 2nd, 3rd, 4th, 9th, 10th, etc. And what you can see is that there's variation even by circuit. So 4th Circuit, relatively low. 10th Circuit, relatively low. 2nd Circuit, 3rd Circuit, 9th Circuit, fairly high. We've not done a lot of statistics on these yet. I can't really tell you significance. I received a lot of this data at 3 o'clock in the morning from my team of RAs. We'll do that next, but it'll be interesting to see whether there are significant differences between these groups of data. Now here's the district courts all aggregated with a gigantic standard deviation. That's a 40% sample of 100%, but even so, it's a gigantic standard deviation. Federal Circuit, as you saw before, there's sort of a step function, district, Federal Circuit, Supreme Court, heading upwards. What I will point out is that every single circuit, the district courts therein, are well above the average importance of 1.0 for the entire population of patents. So there is something going on here, it appears. It appears that important patents are indeed the ones that are litigated. And there may be some interesting stories in this progression and some of the variances between circuits and districts. We've yet to do a lot of time analysis, but here is the importance of the patents litigated at district court, Federal Circuit, and Supreme Court from 2000 to 2014, just to get an idea of whether there's a trend going up or down. We've not normalized it for time yet. We will try and normalize it for time when I get a chance. But you can see, as you might expect, there's actually a sort of a decline in the importance over time because more recent patents are probably litigated more recently, and more recent patents have not had enough time to thrive within the network and gather citations. So this may simply disappear when we normalize. Supreme Court, in part because there's a small population of cases, it sort of jumps all over the place. And at certain times there's gigantically important patents, other times either no patent litigated or less important ones. So, to sort of conclude, it looks like the importance of litigated patents is far higher than the mean for all patents and for non-litigated patents. It tends to rise with court level. Districts vary a lot. The pattern of importance holds for both utility and design. I didn't show you that, but it holds for both those types. Variances are substantial, especially at the level of the federal district. So patents litigated to a decision tend to be much more important than other patents. Patents tend to be progressively more important when litigated at district court level, appeals court level, Federal Circuit, and Supreme Court level. Importances of patents litigated in different district courts varies a lot. And what we're going to do next is explore this statistically. We'd like to produce a topographical map of every district. So we sort of imagine a map of the US, and every district will have a little bar. And I think that might be an interesting way to look at whether, for example, the coasts have really important patents and nothing in the middle. I don't think it's going to be quite that simple, but we also want to analyze the patent importance by specific technology areas and a whole bunch of other factors that we have already in our database. But this is just sort of an initial look. So I want to thank my research assistants who labored mightily over this, especially Nathan Monabach, who worked all summer on this stuff and stayed up till 3 in the morning last night. Max McGraw, Aaron Vanderpool, J.D. Fitzgerald, Edgar Acevedo Pando, who all worked really hard over the last 5-6 months on this. And then we got this, we were given this data from Patent Vector, which has done the analytics for the network. So thanks very much. I think we have time for a couple of questions. Looks like there's 3 minutes left. Sure.
So you said at some points that important patents are litigated, and of course that's not what you're showing the litigated patents are important. So obviously that means that the reason I phrased that more precisely is...
Yeah, you're totally right. That's what I should have said. Sorry for that.
So, but that means some important patents, by your measure, are not litigated. Are
Yes.
you going to look at the differences, if there are any, between the important patents that are litigated and the important patents that are not litigated?
Yeah, that's one of the things we would like to do. It's a question of time and resources, but absolutely, because there's a tremendous number of very important patents that have never been litigated, which is sort of fascinating. One example is the most important patent in the network. Can anybody guess? It's Kerry Mullis's PCR. He's got 3 patents, 1, 2, 3 in the network. anyway, there are some really interesting anomalies that were never touched. There's a variety of reasons, like maybe they were so great that nobody dared infringe, or maybe they were licensed really effectively so litigation never resulted. So yes, we would like to look into that. It's a great suggestion. Yes?
I have some thoughts, maybe I'll catch the output, maybe how you can do that last graph and normalize my time.
Great, great.
On that.
Yeah.
One thing I want to say about the sort of the importance metrics. You know, folks have done the more simple stuff of just using the total number of citations. At least some, I've also seen some of the economists create sort of like generalizability scores, basically trying to see how concentrated are the citations in particular technologies, and assigning importance. If there's a particular patent that's being cited across a more breadth of technology, they'll call that important. So I was just wondering, is there any way that you could use this sort of network analysis to sort of build along these sort of generalizability scores and to do it better than the simple ones that they're forming? Just like arguably what you're doing with your importance measure is just sort of building upon the simple citation count.
Yeah, look, let me take the technology one that you mentioned. We've done a technology study. In fact, I think you saw an early version of it at Northwestern last fall. So we think we can actually shine some light on that particular issue. The fact that the existing classifications, the USPTO, the IPC, are highly flawed classifications. And so this is a very simplistic sort of first order analysis. But yes, we'd like to do that, and we've made a little bit of headway on the technology thing. You also gave some great comments that we've incorporated from last fall on looking at the technology classifications. But yeah, and I look forward to hearing afterwards about your suggestions. Ryan?
I'm still thinking through the questions.
Sure.
The fact that the patent is litigated doesn't mean also that the patent does not meet the requirement for patentability. I just want to take the case of the BRCA 1 and 2 testing.
Sure.
So what do you have to say about that?
About BRC 1 and 2?
No, they can't.
I want everyone to have access to that.
Yeah, I know. But the fact that
No, you're right. So this doesn't necessarily indicate validity.
yeah.
And not only does it not indicate validity necessarily from a global perspective, we haven't really studied, I mean, so maybe it does, but I'm skeptical that it does. But also, when the Supreme Court changes the law, then of course our analysis may have been right and then become wrong based on subject matter, for example. So yeah, there's a very rich interplay, to euphemize, between this and what's actually going on in the courts with respect to doctrine.
Yeah.
I agree.